Welcome to our breakfast briefs on New Year, New Laws. My name is Ziebell. I'm an attorney at Lavelle Law. A little background about our firm, then I'll kind of walk in how this morning's going to go, just so it's a little easier. So our firm's been around for about 30 years. We practice all areas of law. My area of expertise is employment and commercial litigation, so I am a court guy. My colleague, Kelly Anderson, is helping me out in employment law now, and she primarily does residential and commercial real estate. So for this morning, a couple things. One, none of you, or a few of you are our clients, so there's not an attorney-client relationship created this morning. If you want to become our clients, it's great. I highly encourage that. Nothing this morning is considered to be legal advice. It's kind of just my spin on what's going on with the law. And so in that vein, this is really a 10,000-foot overview of the law. And there's two reasons for that. One, statutes are very carefully constructed. Second, a lot of these amendments haven't been tested in court where I spend a lot of my time. So they say what they say, but what that means in the real world really hasn't been determined yet. And then the third reason it's kind of really a high overview is that a lot of these things get delegated out to administrative agencies to get rules. So, for example, if you remember when the Paid Leave Act went into effect, it said you get 1 hour of paid time off for every 40 hours off. They can use it this way, et cetera, et cetera. They didn't actually formalize rules for what a lot of those words and that meant till almost a year later. So a lot of these things are still going to be fleshed out in the agencies. And so a lot of these things, like I said, they're great. They say what they say, but they're not going to be interpreted by courts or the agencies until later. And that's where you get a lot more of the detail and you get into the real nitty gritty about what does this really mean for my business. So I've skipped through 3 slides already.
And
so
it's great.
The graphics are fantastic this morning. So we did have a problem. So what I did try to do, and if anybody doesn't have one, I tried to print out a full page of the slides. So if anybody doesn't have that, let me know. I did want to have mercy on everybody's eyes because my eyesight's not the best, and I know how difficult that can be. So if you want to turn to, I think it's the 4th page, it's the Illinois Human Rights Act. Oh, and one other thing, I will try and be pretty brief, and there's a reason for that. One, again, it's an overview. Two, I love to take questions. I hope you guys came with questions this morning. It doesn't even have to necessarily relate to what we're talking about. I'm sure people have questions. I like to leave that time really open, so I tend to be somewhat brief. So as you're going through, if you have questions about something and I kind of sped through it, feel free to ask me during that period of time. So if you're on the Illinois Human Rights Act page, whenever there's a discrimination type claim, it has kind of a deadline or a statute of limitations, and it's pretty short. Under federal law for the EEOC, it's typically 180 days, although if a state law has a longer period, they will extend it to that period of time. So in Illinois, there's also a kind of a companion to the EEOC, which is the Equal Employment Opportunity Commission. That's the Illinois Department of Human Rights. What this particular provision does, or it says that extends the filing time, is that statute of limitations on an Illinois claim before the Illinois Department of Human Rights is now extended from 300 days, which is slightly less than a year, to a full 2 years. That means that person can bring a discrimination claim under Illinois law for a much longer period of time. Now, the interesting thing is under the EEOC, as I just said, it's 180 days for what's called a Title VII discrimination claim. And then it's 300 days if you're in Illinois. They didn't change that. So in other words, if somebody wants to take an Illinois claim to the EEOC, they still only have 300 days to do it, even though if they did it in Illinois, they'd have a longer period of time. So that may be something that changes, but as of right now, it's shorter with the EEOC, longer with the state of Illinois. From my perspective, practicing in this area, it seems like every year we get some more categories of things that you cannot discriminate against. And the state of Illinois did not disappoint me this year. If you look at the second bullet there, there's now a prohibition on discrimination on the basis of reproductive health decisions, which they've defined to be those decisions relating to fertility treatments, contraception, pregnancy, abortion, and related healthcare decisions. Pregnancy is already kind of a covered class, so I'm not real sure what they gained there. But the other ones are a little bit interesting. I'll be kind of curious to see how the regulations and court cases play this forward. It just seems to me to be another tag add-on to one more thing employers can't look at when they're hiring somebody. If you want to go to the next page, they also added a discrimination on the basis of family responsibilities, which they defined as actual or perceived care of a family member, including meeting medical, hygiene, nutritional, safety, or other emotional support needs for a child, spouse, domestic partner, parent, or other close relative. They didn't define close relative. So there's going to be some interpretation of what that means. Is it your grandfather? Is it a stepmother? Again, a little open on that end, but these are more the cases that you have somebody that's caring primarily, I suppose, a disabled child, disabled spouse, disabled parent, possibly, and you can't discriminate on those bases. So you couldn't, if the person came in and said, I have to take care of my son 2 to 5 Monday through Friday, so I can't work. You couldn't discriminate against them on that basis. Now, it might not fit into what your job role is too, which is a different story. The kind of interesting thing to me that I want to see how it's going to play out is it doesn't require modifying existing company policies on leave, attendance, and performance. So that makes it a little challenging in the sense that if you have an attendance policy and this person can't meet it, how do you kind of thread that needle of not discriminating but still enforcing your policies? Same thing with attendance, same thing on leave. So again, how this gets interpreted by the agencies and courts is, for me personally, going to be kind of interesting to see how it plays out. The last thing, the next page. How many of you use AI in your business in some form or another? Okay, a few. So what they have now done is banning discrimination based on the use of AI in hiring or employment decisions. So what you have to do is if you're using AI to screen employees, applicants, or promoting people, you have to inform them if you're using AI and how it's being used. You also can't use it to discriminate. So you couldn't put in AI, find me all of the Indian applicants on LinkedIn in the last 50 days. And then AI would spit out a list of names. You couldn't do that. So those are the fun things that the state of Illinois has added, and I will turn it over to Kevin.
All right, so we're moving on to the Equal Pay Act, which also is seeing some changes in 2025. And the changes are just designed to ensure greater transparency, fairness, and accountability in pay practices. So this applies to employers with 15 or more employees, and they're going to be required in their job postings to show the pay and benefits information, salary ranges. There has to be both on internal and external job postings. So employers have to include the wage or salary for the position in a job posting. It also needs to include a general description of the benefits or other forms of compensation that are going to be part of that position, stock incentives, things like that. Also, the pay scale has to reflect what the employer reasonably expects to pay for the position. So this can be based on existing pay scale or the amount budgeted for it, but it must be a good faith, reasonable salary range. You can't say the salary range is going to be $1 to $1 million. So it has to be a little too open for interpretation. And the requirement also applies to positions, at least, or to remote positions, at least if they are in part performed in Illinois. Also, if it's somebody that's outside of Illinois that still reports to someone in Illinois, it has to be also for that position too. And finally, if you make an external job posting where you've done this, you also have to notify all current employees of the same opportunity no later than 14 calendar days after you've made that posting, external posting. And so we can move on to the Personnel Record Review Act. There have also been changes in Illinois, and this is also, again, to promote transparency, privacy, employee rights within the workplace, and personnel files. This applies to all employers across the board, both private and public. First, the amendment expands what counts as a personnel record. So not only are they entitled to, their personal, the regular records, they're also entitled to benefits information, employment contracts, handbooks, or policies. That all becomes part of what a personnel record entails. The act provides that the employee has to make its request in writing, has to be, I think before it could just be a verbal request, but now it has to be specifically in writing. And if an employer cannot meet that then once they've made that request, the employer then has 7 working days after the receipt to provide those records. If they can't meet that deadline, the employer can just take an additional 7 days to comply. If an employer doesn't maintain those records, because maybe you don't have all those records, they just need to notify in writing the employee that they don't maintain those records. And the Act has specific requirements for what the written request needs to reflect. It needs to be made to the person responsible for maintaining the personnel records, depending on who that is in your company. It has to identify the records that they're specifically requesting. It has to indicate if they plan to inspect or make copies of their records and receive copies of their records. They have to specify whether or not they want those records in a hard copy or if they want them by electronic format. They also have to specify whether they are going to be personally inspecting them or if they want them given some representative, perhaps some sort of agent. And if the records being requested include any medical information or medical records, you have to have a signed waiver to release that medical information to an employee's representative. The Act does not apply to disclosure of any trade secrets, client list, or financial data for the company. So in practice, the amendment's going to require employers to turn over a lot more information than they previously did. And failure to comply could give a private right of action to an employee. Yeah.
So employment contracts, like say you signed something a couple of years ago, don't have it on hand, and you request it from your employer, can the employer ask the employee why are you requesting it?
I don't know that.
If you have everything in your personnel file, you have a legal right to under this statute. All this amendment did was before, typically, if you asked for your personnel file, generally what you got was maybe your job application, your I-9, your W-4, any tax forms you submitted. That was about it. If there were performance reviews in there, depending on the reason for your ask, you might get those, you might not. There's certain protections that, like, if somebody, the example, somebody's got a discrimination claim and they send a letter to the company and say, I want my personnel file, and there's bad performance reviews in there or something like that, and I might use that in litigation, I can shield that from the employee. But generally speaking, that's what you got. Your personnel file was 8 pages. Now you're able to get the handbook, your employment agreement, some other things, just so you have a little bit fuller picture of, how was I not promoted if that's in there? Why was I promoted? What are my performance reviews? Do I have a non-solicitation in my employment agreement? I don't remember. That's basically what the purpose of the law was. Is, again, people would get a request, they get 8 pages, and it wasn't always the stuff they were looking for. Then sometimes you have an argument with the employer about, well, I want this, that, or the other things. This just clarified that. Okay. I'm going to take questions at that time.
Just moving on to the next, we'll do the Wage Payment and Collection Act, which has also been amended and effective January 1st, changing existing wage statement requirements on employers. And the key changes for new employers, or for employers, creates pay stub obligations, record keeping requirements, and there's penalties obviously for failure to comply. One of the key changes, upon a request from a current or former employee, employers must furnish pay stubs to the employee within 21 days of the request. However, they're not required to grant an employee's request for a copy of pay stub more than twice in a 12-month period. So there is a limit to how many times they can ask. Don't forget, employers have to keep copies of pay stubs for at least 3 years after the payment date, regardless of whether an employee leaves employment ends during that 3 years. And noncompliance can result in penalties of up to $500 per violation. It is in addition to any damages or attorney's fees for wage noncompliance, which is also covered by this, and there's a private right of action if you don't comply. So looking at, moving forward as an employer, you need to be making sure that your pay stubs are compliant, that your record-keeping procedures are in compliance, and that you're keeping these things for a 3-year retention period. Make sure that your staff is trained on this, your payroll staff, and evaluate whether or not your pay stubs are accessible by former employees for 1 year after separation. And establish a good protocol for that. And I will turn it right back over.
So, as many of you know, I'm not a tremendous fan of Illinois' employment laws. They're very employee friendly. And you'll kind of see that as I'm rolling through some of the rest of the changes that are in here and even the ones kind of we've discussed here. But the next one is the Right to Privacy in the Workplace Act. This is an immigration law more than anything else. And basically what it does is it prohibits employers from imposing any work authorization requirement that's greater than that required by federal law. So federal law is pretty lean on that. I mean, really, you have to do an I-9 when you hire somebody to verify they're able to work here. You have to keep that record. There is no requirement that anybody use what's called E-Verify to verify citizenship. That is not a federal requirement. And basically, I think the concern in Illinois was that people would start using E-Verify. So there's no requirement that you do that. Therefore, you can't voluntarily do it. Now, what can happen, I've seen it, is the federal government can come in and do an I-9 audit. And as part of that I-9 audit settlement, you may agree to use E-Verify. That would not fall under this statute. You're not voluntarily doing it. The government's imposing it on you. So that would be the distinction there, but you couldn't just voluntarily do it. There's language in there that prohibits employers from imposing the same. Frankly, I don't know what the difference is. It's the same requirement. So the next slide is the Whistleblower Act. And just kind of as background on what the Whistleblower Act is the Whistleblower Act is set up to protect employees from taking a claim of unsafe practices in an employer to a government agency, and that government agency coming in and investigating, and that company terminating the employer, demoting them, or taking some other action. So the way this was initially set up, or the way that the courts have interpreted, primarily there were some things you had to have. Number one, you had to complain to a public agency. So you had to go to OSHA, the Department of Labor, whatever entity was in that particular area. And you actually had to physically report that there was something going on. I'll give you an easy one, OSHA, occupational safety. So there's an unsafe condition in a place where you work, you complain to OSHA, they come in and do an investigation, you fire that employee because he rattled to OSHA. That would be protected under the Whistleblower Act. What wasn't protected before was if you went to your boss and said, I'm going to go tell OSHA that you have this unsafe practice, and you fired him, you could do that. If he just came to your board of directors and said, I don't like this, that, or the other thing, that you could fire him. That has changed. That's what these amendments do. So they've expanded retaliation to include the threat of disclosure, not just disclosure itself, which is kind of what I was just alluding to. You're threatening to go to OSHA as opposed to you actually physically go to OSHA and make the complaint. So now if you threaten to take some action against a company, that is now protected. Extended an adverse employment action. And this is going to be one. That which a reasonable person would find material adverse or where it could dissuade a reasonable worker from disclosing or threatening to disclose information. Traditionally, in this context of this and discrimination, an adverse employment action is something really concrete, right? You fired the person, you demoted them, you refused to hire them. These are all things that you could look at a certain point in time and say, this is the adverse employment action, this is the bad thing that happened. Now they've gone to a reasonable person standard. So what you might think is threatening, I might not. So this is going to be a very case-specific analysis as opposed to where you look at somebody getting fired. We all can agree that happened. Now, at what point does this person feel threatened or to the point where he's not going to report the information or fear for his job? Could be anything. It's kind of like sexual harassment. One person's sexual harassment is another person's compliment. So this is going to be a very tough standard, and it's very loose compared to what the law was before this. The last bullet point is the extends disclosures and threatened disclosures to not just public bodies, but to certain corporate members, supervisors, officers, board of directors. This is another distinction that, again, broadens the field quite widely. I've done whistleblower cases before. They are not easy because very few people actually go and tell the government about what's going on. So like your classic whistleblower cases, somewhat rare in my world. You do get a lot of these though. I went to the board. I told them there's an unsafe condition. They fired me. They demoted me. Okay, before I was like, sorry, there's really, nothing I can do for you. Now they have a cause of action under the statute. And that comes with attorney's fees and all the other fun stuff, all the other bells and whistles. So this is a pretty big broadening of the law. I don't know how in accordance it is with other states, but it's Illinois, so again, I'm not super surprised. The next bullet is the Child Labor Law of 2024. I'm going to go over this in a real broad strokes because there are a lot of intricacies to it. So if you have minors working for your company, you are supposed to obtain a certificate from the Illinois Department of Labor. The global purpose of this statute is to prevent minors from working crazy hours when they're in school. That's really what it boils down to. So it does restrict minors' working hours. I don't remember what they are specifically right offhand. Again, it varies literally by weekday and weekend. And then there's also some other variances for how often they're at school and some other things of that nature. So it's kind of detailed to look at. And then similarly to certain hazardous activities, there's certain things that they're not allowed to do, period. There are some things they are allowed to do if they are supervised and they're part of a, for example, if you have a kid that's a woodworking class or something like that, he wants to work on a lathe or something, they can do that if they're supervised. So there's these very intricate details about how all of this has to happen. The critical piece for employers is that you do have to obtain the certificate from the Illinois Department of Labor. The next slide is the Biometric Information Privacy Act. How many of you are familiar with that offhand? I know one is here for sure. So the Biometric Information Privacy Act was set up, and I'll give you kind of the real world application. It's very broad. It's supposed to protect like eye scans, fingerprints, certain images of yourself, things like that from people using them. Where it really comes into play and where there have been a lot of lawsuits was people were using fingerprint scans for time cards or even eye scans or things of that nature. And there's an authorization you have to receive from the employee saying, hey, we collect this information. Here's how it's safeguarded. It's destroyed after so much time. It's very intense, I guess. But it's out there, and a lot of companies got sued because they didn't do the disclosure, or they didn't inform the people, or they weren't disposing of it properly. And the law changed on that this year. I'll kind of walk you through the sequencing of it because it's not on here. Bad attorneys, not like me, got wind of this and filed class action lawsuits against companies. So they would get, hundreds of people, thousands, depending on the size of the company, and they would go in and say, you took my fingerprint 250 days last year. We have 100 employees. That's not good this morning. That's 250,000 occurrences, let's say, and it's $1,000 an occurrence. So you owe these plaintiffs $250 million, or whatever the number is. There was a huge judgment. I can't remember who was entered against. I want to say Facebook, if it's the one I'm thinking of. Huge judgment entered against them for using this kind of stuff. And it happened, there's one in Illinois, it was millions of dollars, hundreds of millions of dollars. And in the course of making that, and the reason was because the argument was, well, it's one person, right? So I did this to one person over the course of 250 times. That should be one violation at $1,000 per pop. Didn't work that way because that's not how the court interpreted the law. So what happened was the Illinois Supreme Court said, this is the way the law is, but legislature, you should really think about if you want to do it this way because you're going to put companies out of business if this is how the law is going to be. So what they did was they did amend the law, which quite frankly surprised me a little. So now it reads if there's repeated violations from the same person and using the same method of collection, there's only a single violation and one recovery. So now if you have 250 employees and they bring a lawsuit against you, you're basically dinged one time for each employee, assuming two things. One, it's the same employee. Two, you're using the same collection method. So for example, where you could run into trouble, hypothetically, you use a fingerprint scan, okay? 6 months through the year, you change to a retina scan. Well, now that's a different method of collections. Now you kind of double the problem, so to speak. But this is a good thing for Illinois businesses. It does lower the liability tremendously, just because before it was 1,000 every time that person touched the thing. Oh, you got a person that clocks in at 8 o'clock, clocks out at 12 for lunch, comes back at 1 and clocks out at 5. It's 4 times in a day, 4 times in a week. You can see how that adds up at $1,000. So this was a really good change to the law, frankly. The next slide is the Worker Freedom of Speech Act. Prohibits employers from taking adverse employment actions against an employee who refuses to attend or participate in an employer-sponsored meeting or listen to communications from an employer about religious or political matters. Two kind of distinct definitions here, religious and political. They are somewhat defined in the statute. Again, I think the administrative agencies are going to have to interpret that a lot tighter than they do. I mean, clearly there's some things that you would consider political right off the top. And also there's some things you would consider religious, but there's probably a lot of vagary there. So again, I think that what's going to happen is the administrative agency is going to pare this down more, define it better. Basically, you can't threaten an employee to attend a meeting. You also can't threaten them with an adverse action if they don't attend. So it does provide for a private right of action. So just, to be clear, that means that the employee can sue the company directly. They don't have to go through an administrative agency to come after you. And then you are required to post notice of this statute where employee notices are customarily placed. There's companies that have all of Illinois federal laws on one big poster board. So this will be added to that, I'm sure. The next slide is the Illinois Day and Temporary Labor Services. How many staffing people do I have in here, just out of curiosity? Okay. The rest of you is going to be boring. The Illinois Day Temporary Labor Services Act basically provided that if you had a staffing person and you placed them in a position for more than 90 days, that person had to receive pay and benefits equal to what that company employed offered their employees in that same position. That got enjoined. Meaning somebody went to court, they sued and said, you can't do it on the benefits part. And courts agreed with them. The reason for that is there is federal law that covers defined benefit plans, 401k, your medical, dental, all of that stuff. And this basically encroached into that law improperly. So basically now what you have in the staffing world is if you send somebody for more than 90 days, they have to equal the pay of that person. You do not have to match the benefits, however. All right, so that's got to the end. Not bad, I'm about on time. Questions? Go ahead.
On that last one with the temp services, mentioned the pay. What about paid time off? Is
That would be a
part of
benefit.
pay,
That's a
or is that
benefit.
considered part of the
That's
benefit?
considered defined benefit.
That's considered. Okay.
Now, again, realistically, you're probably, you have to offer your person paid time off under the statute anyway, so.
Right, I know they have to follow, but if you've got clients that offers more than that to their full-time staff.
Sure.
you know,
Yeah, it's part of their benefits package.
Okay.
Yes, I'm gonna call on Alan. Alan's a lawyer. Alan likes to bust my chops, so this might get interesting.
Mr. Ziebell, there was three slides that you showed today that talked about private actions.
Mhm.
If a private person files a private action, are they entitled to an attorney's fees?
It depends on the statute, quite frankly. For example, under the Wage Payment and Collection Act, there are attorney's fees. Under the Whistleblower Act, there are attorney's fees. It's always statute specific. Not every statute provides for attorney's fees. Those are the two right off the top of my head that do. Title VII, your discrimination laws, those also provide for attorney's fees. They also provide for treble damages and punitive damages and compensatory damages that, like the Wage Payment and Collection Act, don't necessarily. Wage Payment and Collection Act, I believe it's treble damages and interest from the date that the payment was due. The Whistleblower Act, I believe there are punitive damages under that as well.
Thank
Yes, ma'am.
A couple questions. With the Illinois Day in Temporary Labor Services, is it only for staffing agencies or is it for direct hire temps as well?
Well, your direct hire temp, are you placing them in there for longer than 90 days or are you putting them right into the position?
I guess it depends.
So if you're doing a direct to hire and they had like a 120-day trial period, let's just say. Once that 90 days clicked in, then you would get into that realm of possibly having to have that problem. If it's less than 90 days, then no. If the direct hire doesn't really it's the timing more than the nature of the agency.
It could be seasonal, for example.
Sure.
in some return or something like that. The other question I had, well, it's a great question. The Worker Freedom of Speech Act, is that what's more commonly known as the captive audience? Or is that something different?
Yes and no. Captive audience is really more of a union issue. So when you hear a captive audience, traditionally what I think about is an audience where the employer requires them to be there to talk about a labor union. That's traditionally how captive audience is used. Could this be viewed in a similar sense? Yes. Hypothetically, it's got the same connotation, but that's not what it triggers when you're talking about that particular language.
And then my last question, on your personnel record review app, when you talk about handbooks, being a part of the record and policies affecting employee qualifications, handbooks are generally made available to employees. Does it have to be for, like, the handbook at the time they were hired? And the policies affecting employment qualifications, is that like something, is that a recruitment policy or is that a job description? What does that look like?
So I'll take the second part first because it's maybe a little bit easier. Job description. What are you looking at to hire this person? And if they're going to be promoted, what's that next job position look like? If they're not, for example, if you considered the person for a promotion from assistant manager to manager and you determined that he didn't have certain qualifications that you wanted in a manager and that person wanted that personnel file, you might need to include the manager job qualifications so you're able to support, well, you didn't have ABC skill. As far as the handbook goes, my position on that would be, and again, I have to clarify this, my position would be that you would provide the most recent handbook, not necessarily the one they received when they are hired. There's a caveat with that law. A lot of, I'm not going to say a lot, some companies have their handbooks online. They have other personnel information online. If that information is available to the person online, the company merely needs to point the person to that online information. For example, if you have Paylocity, you have all your benefits in there, you would instruct that person, you want your personnel file, go to www.paylocity, log in, get your information. You don't have to print out 700 pages of personnel file in that case. Ms. Ruche, one of my colleagues.
Just a ordinary person back here question. You mentioned that a personnel review record that an employer can withhold a bad review for purposes of litigation later. Can the employee challenge the employer's withholding of that based on failure to disclose pursuant to their request under the act?
Two ways they can hypothetically do that. Number one, they could bring a complaint with the Illinois Department of Labor and say that you're not turning over my personnel file, and that would get adjudicated that way. The second way that they would protest that is a little more involved. Let's assume, let's play your hypothetical forward a little bit. Joe Smith, we withhold his review or withhold some documents into the personnel file because it relates to a claim we think he has against the company. Joe Smith files suit, you try to introduce those documents into the lawsuit and he objects. And the court rules that you were wrong to withhold them and you can't enter those documents, etc. That's the other way down. So one, Department of Labor. Two, if it gets to some sort of litigation posture, you could have an issue using those documents there. Anybody else? Yes, sir.
On the Biometric Privacy Act, what constitutes improper collection versus proper collection?
The primary driver of proper versus improper is the authorization. The authorization has to have very specific language in it. I've crafted a few of these before about, how you're obtaining the information. If there's a third party having it, if a third party has it, what are their retention policies? What is your retention policy on that information? That's kind of the primary driver between proper and improper is just authorization to do it.
How do you deal with that if you implement new technology? You implement it, how do you deal with that authorization?
Probably just update it, just like you would a handbook.
I see.
You up every time. Again, my suggestion, and I'm gonna do a shameless plug in a second before we take more questions. But the way you do, every time you update a handbook, you want to get a new signature from the employee. If you change your policies or there's something in there that's drastic, you want to make sure that you have their, not authorization, their John Hancock on that they read it, even if they didn't read it. Shameless plug, so we're doing a handbook review, $750 flat fee. It's basically full review to tell you kind of where you're weak. Doesn't cover modifications because those can take sometimes. So not a bad deal, but just throwing that out there for you. I think there's a brochure for it somewhere. Yes, Mr. Gage.
On the child labor law, hire some kid to mow your lawn during the summer. You have to really get a certificate authorizing it. So what's the requirement, how much the child works, where he works?
It's more about how much the child's going to work. I don't remember what the number is right offhand, but there is a specific number, and then it gets into what they can and can't do as well, more specifically. But you hire a kid to shovel your driveway and pay him cash. Ideally, the state of Illinois is not going to know about that.
What about family members?
Doesn't, it's still a minor, so there's no
So you have to
exception.
get the certificate with hire a family member, a kid?
And usually what ends up happening with these certificates is the parents have to sign off on it anyway, so.
Okay.
So only minor, under 18?
18, so 17, 16.
And how is that different from a work permit that you can get through like high school, for example? Or is the high school act as an agent?
I think the only part the high school is gonna play anymore is more related to trade programs as opposed to general certification. So again, this just came out and they haven't formulated a lot of this, so it seems like they're stepping on a lot of people's toes, because I know they used to do it through the high school, more commonly.
Yeah, so now I'm thinking of my own kids.
But, right, yeah, now you've gotta look into that, but again, it's,
Department of Labor, because my son is 17.
right, my son, again, you didn't hear this here, Sam, turn off this recording. But my son's 16, he works for the park district. Am I gonna go trifle with the state of Illinois? That, it's the employer's problem, frankly, for my end. If they ask me to get it, I would. But if they don't ask me to get it, I'm not putting any more of my information in front of this wonderful state. You didn't hear that. Other questions? Yes, ma'am.
On the pay transparency, sometimes organizations will need to replace an executive that's still sitting and they do a confidential search. But then if you're having to be transparent about wages, I guess I'm just wondering.
You can use a range. I think sometimes there's a way that we would do that. I mean, if your executive is making $250,000 and you put out a job posting that says 250,000. I don't think the math's gonna be real hard to figure out what you're doing there. You can use a range of, you can use a range of benefits as well.
But if, let's say they're using a recruitment firm and the recruitment firm's doing it for them, then does the company have to post that they're searching for this position?
Within the organization,
Right.
I think it's only if you make it available within the organization. I don't think you're required to offer everybody a job that's in your own company.
So,
You can use now, so like, you use Indeed, for example. You have to put in there for the ad,
Right.
for information. But you might not offer
but
that.
if it's confidential, you don't have to
Well, in the,
post it with
right,
your own company.
here's an example, you have an office full of lawyers, and we need to hire a receptionist. We don't have a receptionist, so I go on Indeed. Am I gonna offer the other lawyers in my firm the receptionist job?
Right.
They might take it, but I mean, probably, that, so you don't have to, it's only if you're gonna offer it in-house, that you have to do it within that time.
Okay.
Yes, ma'am.
One question about the Illinois Paid Leave Act, because I just can't remember right now. Are accrued hours required to roll forward into the new calendar year?
Yeah, the trick question. Depends. It depends. And the reason I say it depends is you can front load the hours.
Right?
If you front load, you're not required to allow carryover.
Okay.
If you do not front load the hours, you have to allow carryover.
Okay, thank you.
I have a question about pay stubs. It said, twice a year, somebody can request. But are you, as an employee or an employer, obligated to provide one, every time there's paid?
Yes.
You are. You should, in fact, because most people are paid electronically these days. So pushing the money into the bank isn't good enough. You need to give them a copy of the pension.
Correct.
At that time.
Yes.
And it's mandatory.
Yes. So the way that, the wage payment collection act is set up is you have to, and I'm not gonna get into the specific timing, I don't know it by heart, but when a person's paid, they have to get a check stub that shows their gross income, hours, deductions, et cetera. You have to keep those for 3 years. I cannot tell you the number of problems I've had with people not keeping time cards and pay records for 3 years. Biggest problem I see for companies. But yeah, you have to give them a check stub every time. It's like, I get, my paycheck stub is electronic now too.
So that's what I'm thinking, yeah, most people can log on and get, that's acceptable.
Yes. They have to have access to it. I use Paylocity.
Okay.
I get a
So you never get a paper pension?
I get a little pop-up thing on my Paylocity every few weeks. It says, you have a new check stub. Great. It's up to me to look at it, but they've provided it to me.
Okay.
Whether I choose to look at it or not is kind of my own issue, but you have to provide it, let's put it that way. You have to physically put it in their hand, you have to give them access to it. Yes, sir.
Few things. Is it true that 1 out of 5 employers list you're legally required to list that you're hiring, but one trend seems to be there's a good percentage that they're not even hiring? I've heard, I don't know if that's true, but secondly, do you see them having to say, like, if they're gonna promote it internally and they do a listing, will they eventually have to be transparent about we're not hiring externally?
I don't think,
Is that trend true, or is that
I think the,
mainstream?
if you're asking generally about the law and what it requires is what they're looking for. It's not meant to control how or where and in what fashion a company hires. All it's really requiring is if you do hire, here's the information you have to give a potential applicant. So if you're hiring by word of mouth, okay, that's not a posting, right? So it's not required. You can do that however you want. You can hire in whatever fashion you want. It's only if you use certain methods, then at that point, there's a requirement that you be transparent about what the pay and benefits are.
So it's more about the thing, not or how the comp.
It's more about method than anything else.
Okay.
Yes, sir.
Lance, do you know when the Illinois Day and Temporary Labor Services Act was
Enjoy.
consummated? So it came out about 18 months ago,
Yes.
and then
our governor, what's his, yes. Thank you.
I don't think it's one.
He said that it was gonna be either consummated or not in May of last year or April of last year.
Yeah, it went into effect. I guess I don't know what you mean by consummated. The law was in effect. So I mean, it was an applicable statute on the books that was enforceable. And then what ended up happening instead is they got sued and you can't kind of mess with this overarching federal defined benefit structure. But the rest of it's still there. It's just that one piece that's been carved out, so to speak. Anyone? Yes, ma'am.
On the E-Verify, I know some small businesses were signing up for it because then they felt confident that they were doing what they were supposed to do, and
And now they can't
now they can't do that.
do it voluntarily.
What if your client mandates that you have to verify on a potential employee?
Then you're not voluntary at that point. That would be my take on it. Again, new law, they haven't really interpreted what voluntary means. The way that I read that is you couldn't just as an employer say, I'm just gonna start using E-Verify now. Now, again, there are certain situations, there may be certain contractual obligations. For example, if you have federal government contracts, they may require that you use E-Verify. That's not voluntary at that point. Again, if the Department of Homeland Security comes in and does an I-9 audit, part of that settlement might be, we're gonna require you to use E-Verify, also not voluntary. So that the tricky word there is voluntary. Well, what is voluntary not? To me, voluntary in the broader sense is you couldn't just implement it to make your life easier. However, if it's a requirement of some other contractual obligation or it's imposed on you by somebody, that's obviously not voluntary.
But if you already have it, you already have it.
You already have it. I don't think they can divest you of having it, let me put it that way. It's prospective in that sense. Anybody else?
Are any of these changes retroactive or they
Very-
start January 1st?
They start January first. Very rarely is the law retroactive, because you just run into too many problems with it.
I know, but I hope I don't ask it.
It's all been one. None of these are, to the best of my knowledge. Anybody else? Awesome. Well, thank you all for coming. I'm going to get you out of here 11 minutes early, so I am good.
Thank you very much.
You get everything?
Lori, were you trying to tell me?
Right.